before we get started. We have Code Studio, who's been helping with a lot of the coding work, and we have Christy and Bahizi here with Code Studio. We also have Jeff Haymore, who has been helping with legal review. And then very importantly, for those of you who are in this room tonight or who are joining online, we have Content Consulting, Yinka and Andrea, who have been helping behind the scenes sort of pull this all together. So I'd like to thank them very much for all the work that they've done. And thank you very much for coming out to learn about the final module of the Atlanta zoning rewrite. Now, a second here. So our agenda tonight is going to be to give you a very brief update of the process of the zoning rewrite. For those of you who have come to previous meetings, there won't be anything new per se, but for those of you who may be new, this will give you a little bit of background into what we're doing. We're then going to talk about the draft administrative processes of the code. This is the proposed part of the zoning ordinance that will regulate the procedures that regulate and control development. So how do you file a rezoning? How do you file a variance? How do you get a zoning permit review? We'll then have a very brief Q&A session, and the Q&A session is really going to focus on sort of process rather than questions related to the content, and then we'll talk a little bit about next steps. And I wanted to remind everyone that the purpose of this meeting is to really introduce you to Module 3. We know it's a relatively long document, which you'll be able to go home, review on your own time. And then like previous meetings, we are going to follow up with an online Q&A session to answer any questions that you may have. We know this is going to be a very technical meeting, and we don't expect anyone to be able to process everything we talk about. We want you to get an introduction, go home, read through it, and then come back to us on March 17th. So in terms of process, we are here again to really add a very important part in the city of Atlanta's history, where the city is jointly updating its comprehensive plan, known as Plan A, and its zoning ordinance at the same time. And this is really the way that communities should think about both planning and zoning regulation. Now, for those of you who are not familiar with those terms, the comprehensive plan is essentially the vision or the plan for the city of Atlanta. It lays out very high-level ideals, has a vision for land use across the city, and a series of sort of written policies. But the comprehensive plan has no force of law. The law is actually in the zoning ordinance. And so everything that we've done to date has really been about supporting current comprehensive plan policies and, very importantly, policies that are emerging from the draft Plan A, which I'll talk about momentarily. We've been coordinating these processes for several years. We're getting very close to the end of documents for those processes, and Nate Holtzell is in the back of the room here. He's been leading the comp plan process, and it's just been very, very important. And why is it so important to do both of these processes at the same time? Well, as the person working on the coding, we know that a lot of concerns of neighborhoods, a lot of concerns of communities can't necessarily determine whether their concern is best to go into the comprehensive plan or best to go into the zoning ordinance. And so this way, we have been sharing information with the CDP team. We have been sort of directing the input from the community into the appropriate document, either the comprehensive plan or the zoning code. And we're going to continue to do that until both of them are wrapped up. With that said, again, we are at a very important part of the comprehensive plan, and I'd like to take 30 seconds to encourage everyone, both in the room and at home, to please consider attending the Plan A open house to actually review the full draft plan. It is going to be 2/6, which I believe is Friday, Nate, is that correct? Thursday, 5:30 to 8 p.m. City Hall. And you can register at atlantaforall.com/events. Again, that's Thursday, 5:30 to 8, City Hall. Register at atlantaforall.com events. And that'll sort of update you on the comp plan and let you share your thoughts into that document. Now, in terms of zoning, we are also unveiling the zoning code incrementally. If this is your first meeting, you are really at the third of 3 meetings where we've been releasing parts of the zoning ordinance in sort of bite-sized pieces, if you will. We've been trying to identify types of regulations that are similar and releasing those in little pieces. Now, it's very important to remind everyone that the draft ordinances before you today, tomorrow, up until we have an official draft that goes before the city for adoption, are discussion drafts. And so as you hear the presentation this evening, please keep in mind that we're very aware that there may still be some details that we need to work out. We're very aware that some of the ideas that we talk about may generate a lot of public conversation, and that's intentional, right? We find that the public can give us the most constructive feedback when they have something to respond to. And we have a wonderful website set up where you can go and review all of the draft documents. It's called atlzoning.com. And if you go to the top right, there's a red button that will take you to all the drafts. You can read them. You can actually put your comments in there. You can see what other folks have said. And then me or my fellow team members have been answering those every couple of days. So it's a really great opportunity to hear what your neighbors are thinking, to share your own comments, and then to have any questions answered that you may. And together, these three modules, Module 1, Module 2, and Module 3, are going to be out there for review and discussion until the end of March 31st. So if you are new to the process, you can review any of those modules between now and then. You can share your thoughts between now and then. And we're gonna continue to update the modules as we go through the process. However, after March 31st, we are going to sit down as a consultant team with city staff, and we're gonna review everyone's comments. We're gonna identify areas where there may need to be a little bit more focus, and then we're gonna prepare the first draft of the complete code. Jeff, could you hold up one of the modules, for example? Right now, what we've done is we've basically released the zoning ordinance in chapters. But by April, say, after March 31st, we're gonna take all of these chapters, we're gonna put them into a single document, we're gonna revise them, and that'll be the first 100% draft of the zoning ordinance. We'll probably make a couple of additional rounds of revisions to that. And only after that, only after we felt very confident that that draft document is in a position where it can go before the city for introduction, will we conclude that process. So for those of you who are new, I wanted to tell you very briefly about what some of the modules that we're not going to talk about tonight have related to. The first one was Module 1, which was about form and use. These are basically the zoning district requirements. These are where you're going to find out how big a house you can build on a property, what is your minimum lot size, what are the uses on that property, and what are the standards. Now, we've come up with a proposal to create a new way of naming zoning districts such that there is a set of standards related to the physical form, and then there's a set of standards related to the use of the property. And the idea here is that there may be areas of the city that decide that they want to be able to customize the zoning regulations. And this combination of form and use makes it much, much, much easier than the current process that we have today. So we think it's something that will do a great job of implementing the comprehensive plan, and very importantly, implementing neighborhood plans as they come out. In December, we unveiled the first draft of Module 4, called Development Standards. This was a very lengthy part of the code that basically contained all of the regulations that are not zoning districts. So there were things in there like parking requirements and streetscapes, and how do we handle walls and fences, and how do we handle lighting. That was unveiled on December 4th. We had a Q&A session a couple of weeks ago on January 13th, and we are still in the process of getting feedback. Now, for those of you who have read that, you may have noticed that there were two sections that were not included. The first one is development bonuses. What this means is that there are current procedures in the city to grant higher density in certain areas for doing certain things. We hadn't quite figured that language out yet, but we're going to be unveiling that very shortly. And then we're also going to be unveiling very shortly the sign ordinance. Again, both of these are just going to be cleanups of current regulations. We're not changing anything, but we have to prepare the graphics, and we'll be releasing that very shortly. And then the meeting tonight is really the administrative process. Again, this is about how do projects get approved? How do we handle what we call nonconformities or grandfathers in most people's mind? And how do we enforce the zoning ordinance? We're going to again present it tonight, just so you can be familiar with the document when you read through it. And then we'll have a follow-up Q&A on March 17th. And then finally, I did want to mention to folks that there are a couple of things that are not part of the zoning ordinance today and will not be part of the proposed zoning ordinance. These include the tree ordinance, the tree protection ordinance, which is currently sort of working its way through a parallel process. We are coordinating with them. I noticed several of you have given compliments to the way that we've done that in the draft ordinance, and we appreciate those compliments. But there's also stormwater regulations that come from the state and the watershed management. There's soil regulations that come from the state of Georgia, flood regulations that come from the state of Georgia, and then noise provisions. None of these are in zoning, but they're very important to zoning. Additionally, building code is not part of the zoning ordinance, so we haven't changed anything there. We're not really working with that. And then finally, housing code. So again, these are out there. They relate to zoning, but to the extent that they are in the zoning ordinance or not in the zoning ordinance, they're really separate projects. And then finally, I did want to mention the zoning map, because again, a lot of folks have asked me about this as well. The zoning map is the map the city of Atlanta keeps that tells you what a property is zoned. So every property in the city has zoning. They range from R1, which is a very large lot residential, all the way to SPI1, which is downtown Atlanta. So a whole range of densities. Now, as part of this rewrite, we are not changing the zoning of property. So if your property is zoned for a single unit house today, it will be zoned for a single unit house when the new code is adopted. If your property is in downtown Atlanta and is zoned for 100-story buildings today, it will be zoned for 100-story buildings when the code is adopted. But we are going to be changing the names of districts, as I mentioned. And we anticipate that once the new code is adopted, there's going to be a lot of interest in neighborhoods to use some of the new approaches to zoning districts that are in here. And so that'll be the time to work with your elected officials, to work with the Department of City Planning, to work with the community to come up with tools for adopting that. But we are not changing the zoning initially as part of this process. So with that said, that sort of gives an overview of the process. We'll now get to the purpose of tonight's meeting. And in a moment, I am going to be turning it over to Jeff Haymore with our legal team, because unlike all of the other parts of the zoning ordinance that we've presented today, the administration of a zoning ordinance is heavily regulated by state law, by the federal constitution, and by case law. In the case of Georgia, we have something called the Georgia Zoning Procedures Law, which really restricts what cities can do in their administrative procedures. There are various cases associated with how the Georgia courts have interpreted that. And so I am not qualified to speak about that particular provision. So I'm going to turn it over to my colleague, again, Jeff Haymore. Jeff is an attorney with a specialty in land use law and zoning, and has been very important in putting this provision together. So Jeff.
Well, thank you, Caleb. It's quite an opportunity to be here together tonight and hopefully learn some important things. As Caleb said, a little bit of this can sometimes be a little dry in the sense that we're talking about largely process. This chapter that we're discussing tonight is entitled Administration, and it really is how the zoning ordinance is administered, from something as simple as maybe a dwelling, or maybe something as simple as a shed in the backyard, all the way to new construction. As Caleb said, This is going to be a little bit controlled by federal law, but largely by state law and some case law. As he said, in Georgia, it's the zoning procedures law. Now, if there are just a couple things, if nothing more than these two things, if you can remember, is what's guided us is the idea of trying to make this as simple as possible and to put in one central location in this chapter all the procedures that would go into administering the zoning ordinance. Currently, those procedures are found in various chapters of the zoning ordinance. We're trying to centralize that. And the other thing is we're trying to make it more visual. So if you look on this slide, at the very beginning of the chapter, we have this summary table. And its purpose is to summarize on the rows all the various approval processes. Things like legislative review, those include rezonings. Those include amendments to the text of the zoning ordinance, special use permits, as well as historic reviews, various permit reviews, and we'll talk a little bit more about those, as well as decisions by the Board of Zoning Adjustment. And then in the columns are the various entities that would review those applications. And so you'll see here with some letters, and there's a legend or key down at the bottom. RR means review and recommend, and RC means review and comment. One of the things that we're putting in the front and center is a codification of the NPU role. Now, NPUs are obviously very well established in Georgia, but when you look at the zoning ordinance currently, there's not a lot in there about the role of the NPU. And so we're making it very clear at the beginning that NPUs have a review and recommendation role for all the legislative reviews. So again, we're not changing the substance, we're putting it codified in the code in an area that makes it easy to understand. Similarly, for development review committees, there are multiple development review committees that have been created by resolution of the city council throughout the years. But that's not really codified into the code. And so we're making it more central, as I said earlier, easier to understand. The zoning review board, that is going to stay the same, obviously. This is the exclusive forum for the public hearings that come before a decision to rezone property or to change the text of the ordinance or to grant a special use permit. The Board of Zoning Adjustment, that is the body that decides cases on variances. That will not change. We are eliminating the need for special exceptions. There are a few things in the zoning ordinance currently that are done by special exception. We believe that those can be done by variance. So what are those common review procedures? Well, in a legislative review, they entail newspaper publication, they entail a sign in front of the property, as well as letter notification. That's to property owners within 300 feet. That won't change. Those are minimum requirements, either of state law or the current zoning ordinance that will be kept the same. As well as the duty of the Director of the Office of Zoning and Development to review and make recommendations on rezonings and on special use permits. Again, we're formalizing in the code the role of the NPU to review those rezoning proposals, as well as to make recommendations, similar type processes for variances. So again, those aren't really changing at all in terms of substance, but putting them in one central location. Now, under administrative relief, and we'll talk a little bit more about what that means, we're going to maintain and enhance the director's role to review and decide certain types of relief that I'll talk about in just a little bit. And again, with the same trend, formalizing the NPU review and comment role. In addition to rezonings, the Director of the Office of Zoning Development reviews building permits, certificates of occupancy, and business licenses for zoning compliance. We're going to maintain all of those administrative processes and streamline them in a way that will be more efficient. Concept review committees. A few years back, the city by resolution created a concept review committee, or CRC. The intent of this committee is before a rezoning application is filed, that the applicant meet with various departments within the city. And the goal of that is to discuss issues on the front end before they become more challenging at the end. We're going to put that again into this chapter in a way that's easier to understand. So if you think about it, if you want to apply for a rezoning, you can go to this chapter and in really easy fashion understand the various steps. Same for a variance or a building permit, whatever the case may be. Again, we're updating the code to reflect more recent changes in state law. So for example, the law was changed a few years ago for variances. They require minimum notification to be published in the newspaper for 30 days. Whereas for rezonings and text amendments and use permits, it's 15 days is the minimum. So we're just updating that to be compliant with state law. Also codifying again, a more recent state law change involving when the city if it were to initiate any rezoning from a single unit to a multi-unit housing, then there would be that process, as well as one for annexation. As Caleb mentioned, again, rezoning could be in the form of a change in the zoning map from one classification to another. That would include either a change to the form or the use district, as well as from time to time changes to the text of the zoning ordinance. One of the things that the city currently has is a transfer of development rights program. Now, this is a program authorized by state enabling legislation, and we're putting it again into one simple chapter. This will continue to be done by special use permit, reviewed by and decided by the city council after input both from the MPU as well as from the director of the Office of Zoning and Development. Now, development rights that can be transferred include floor area ratio. So a TDR, in short, is this idea that on some properties, there are excess rights that have never been used and built. And the idea is that you can sever or take those rights off those properties, typically to preserve either a historic building or something of environmental sensitivity, and transfer those rights to a different district or a different part of the city or even close by where those development rights can be applied. That's called the transfer of development right process. We're proposing that development right include not only floor area ratio, but additional height. We'll talk about that in just a second. Sending areas right now are landmark building sites or historic building sites, as well as those special characteristics, woodlands, natural habitats, and wetlands. We're proposing to maintain that, but we're also proposing to expand the sending areas to include non-residential buildings greater than 5,000 square feet in what are called landmark districts or historic districts. And the intent there is to incentivize and hopefully preserve more buildings within the city. The receiving areas, as I mentioned, are those areas where these development rights can be transferred to. We're recommending, as currently in the ordinance, that those receiving areas continue to be in the mixed use and multifamily multi-unit districts, as well as in certain legacy districts, such as SBI 2, 9, 12, and 16. One of the things that we are recommending to be added to the TDR program is a requirement that on those receiving sites, that at least a minimum of 5% of the units be set aside for those making less than 80% of AMI. And that's the floor. If you transfer into a district where it might have a higher affordability requirement, well, then you would meet that higher requirement. But at a minimum, there would be a 5% set aside. Again, we're going to clarify some procedures about sending properties, what that means to have special characteristics. We're going to require that if you sever those rights from those environmentally sensitive areas, that you offer that to be dedicated or sold to the city for perpetual preservation. And as part of that process, you would engage with the city council and seek a resolution that they have an interest in acquiring that property for public preservation. Another important point is on the suitability of the receiving property. Oftentimes, when you think of a TDR, there's not much debate about severing rights and preserving a historic building or a sensitive piece of property. It's more about when those rights are applied in a new area. Is that property that would receive that additional density, is it appropriate? How will it impact the surrounding properties and the surrounding neighborhoods? So tightening up that definition of suitable. And so the city council and all the reviewing entities, including the MPU, would be looking at this standard, which is that it have no substantial adverse environmental, economic, or social impacts to the receiving property, as well as the neighboring properties by transferring those rights. We'll also have a more robust registry for recording where those transfers occur and when they're assigned and transferred to other property owners. Now, this is a fairly big one. We're proposing to eliminate what are called special administrative permits. And I'll talk a little bit about that and explain what we're recommending to replace it. So right now, in some zoning districts, before you can apply for a building permit, you must obtain what's called a special administrative permit. And in other districts, you can go right to building permitting. And we think that those different processes don't make a lot of sense based just on the learned experience. What we're recommending is if someone proposes a zoning plan that's strictly in accord with the zoning requirements, then they can apply for a building permit directly. And within that permitting review by the Office of Zoning and Development, they can make that assessment if it complies with the code. Now, in cases where there's not strict compliance, cases where relief is sought administratively, we would have a separate process for that. And we'll talk about that in just a little bit. And again, the whole point is to have a more streamlined review for projects that meet all zoning standards. And then again, if there are variations that are requested, that would go through a more conventional SAP type process. Now, I want to be clear on this point. Development review committees. There are currently, as I mentioned earlier, various development review committees that exist within certain parts of the city. Those entities have been created through the years by resolution of the city council, but they haven't really been codified into the zoning ordinance. So number one, we're going to put those into the ordinance. Number two, if your property is within a geography that encompasses a DRC, you would continue to have your project reviewed by that DRC, but we're putting a little bit more flesh around what that review process entails. So for instance, you do now have an affirmative requirement to appear in front of the Development Review Committee to present your project. And that review would then take on a 45-day window in which the DRC can provide that review and recommendation, including any administrative review sought. That review would run concurrent with the review by the Director of the Office of Zoning and Development. So again, not really any substantive changes, just putting a more defined role around it, putting it into the code. Also within Chapter 9, we're going to address temporary uses. Now, within the various zoning districts, and this is within one of the other modules, temporary uses are allowed. And so we're going to have a little bit of a formalized process for that. Now, for things that are what are called special events, those are large events. Think of the Super Bowl or the Final Four, large gatherings. Those are typically reviewed through the mayor's office of special events. So if you're in that process, you would go through that process. But if they're smaller type things, temporary uses on property, this would have a temporary use review through the Director of the Office of Zoning and Development. By temporary, we mean 90 days or less. If you want to use your property for a more permanent type use for 90 days or more, that would be by special use permit. Let me be clear on what these temporary uses are and are not. So if they're just simply outdoor sales associated with the business, so think of like Home Depot that might have their wares out in the parking lot. That's just an accessory to that use. That's not a temporary use. These are things like maybe there's a barbecue vendor at a gas station. Maybe there's an outdoor market. Maybe it's on the weekends. Maybe there's a food truck on private property, again, for 90 days or less. That would come through a permit review through the Office of Zoning and Development. Now, under this administrative relief that I mentioned, we're proposing two different types. So again, if you're proposing your project for strict compliance with the zoning ordinance, you have your review within the context of a building permit. But there are situations where you need certain relief, variation, if you will, from strict compliance. Sometimes that's very modest relief. Maybe the sidewalk requirement is 10 feet wide, and for your property, there's only 9 feet available. So you need maybe a 10%, something like that, deviation. You would apply for a certificate of administrative modification. And those are only for those standards and in those districts that allow that type of administrative relief. That would get reviewed by the Director of the Office of Zoning and Development. And again, if you're within one of those development review committees, you would continue to have it reviewed by the DRC as well. Second, if you're seeking modification beyond generally 10% up to roughly 30%, there's what's called a certificate of administrative variation. And again, only in those areas and for those specific standards found within chapters 3, which are the rules for zoning districts, and chapter 8, development standards. Beyond that, you would continue to go to the Board of Zoning Adjustment. We'll do a Q&A in just a moment. If I could just go through a few of these. I am almost done. Again, the certificate of administrative variation is decided by the Office of Zoning and Development, by the Director. There is review and comment by the Neighborhood Planning Unit, and the criteria before the Director could approve such a variation, it would be the same criteria that are currently found for special administrative permits. So you would need to make a showing that what you're proposing, although not in strict compliance, provides protection to an equivalent or greater degree, or that strict compliance in your particular case, your particular piece of property, isn't necessary to achieve the public purpose. Importantly, if you were to obtain one of these variations, a sign would be posted at your property, affording everyone who disagrees with any decision the opportunity to appeal. That's a new provision that we propose. And then the other thing is these administrative reliefs are not open-ended. They're for a period of time not to exceed 36 months, unless a building permit is either filed and pending or a permit has been issued. So that's a deviation from an SAP, which is open-ended. Let me shift here a little bit to nonconformities. And what I mean by that is a use or a building or a use in a building in combination that when it started, it was lawful. It was allowed by the ordinance. But over the time, an amendment to the ordinance changed the rules, and you could no longer build that anew. Well, that becomes what's called a lawful non-conforming use. In short, grandfathered. You can keep it, you just couldn't build it again. And so there's a whole chapter in the current ordinance that deals with how you look at non-conformities. Right now, when the 1982 ordinance was adopted, there's a distinction between structures that were minor, $5,000 or less in value, and one set of rules for those, and then structures greater than $5,000 in value. Well, that may have made sense in 1982, but just about anything you build today is going to be more than 5,000. So that's just simply eliminating rules that don't really apply anymore. But here's the general rule for nonconformities. If you're grandfathered, you can continue that use for that property, that building indefinitely. There's no sunset on it. So long as you don't cease that use for more than 12 months or convert it to another use. That's the current rule currently. If it sits vacant for more than 12 months, you might not be able to reuse it. So we're not recommending to change that general rule. Now, with regard to what you have, you can kind of keep it, but you can't expand and grow it generally. You get what you have, and that's about it. So what happens when there's a casualty? There's a fire or some other type of event, and the home is destroyed. What happens then? Well, the rule currently, and the one that we're proposing to maintain, is that for 1 or 2 unit structures, your home or your duplex, if it's destroyed by any means, you get to rebuild. No questions asked. You rebuild on the same foundation, the same location, with the same height, you get what you had. Well, in other situations, all other type of non-conforming structures, if it's an accidental destruction, then again, you can rebuild on the same foundation, to the same location and height for a permitted use. Now, if you intentionally destroy your building, well, by more than 60%, you need to, and you want to rebuild, that's fine, but you need to rebuild according to the current requirements. That's the current law right now. And then what about if there's destruction that is less than 60%? Well, again, you can restore it to the same location and size or less size if you begin in earnest within 12 months. Otherwise, you need to conform to the current ordinance. The idea then is really a balancing, if you think about, of rights, your ability to build back what you had, at the same time, not perpetuating a nonconformity that doesn't further the purposes of the zoning ordinance. A couple other important parts that we're recommending in the neighborhood scale, those are the R1, R2, R3 type districts. Let's say you have a home that's 1 story and you want to build a 2nd story. A few years ago, the council changed the rules so you didn't have to any longer go back and get a variance. And so right now, the current rule and the one that we're proposing is to maintain that. If you want to build a 2nd story on your home, and that 2nd story would encroach into the setback, so long as you go straight up, you don't get further into the setback, you can do that up to the maximum district height, which is 35 feet. There's a little variation there. I won't go into that in too much detail. But basically, the bottom line is you can add on a 2nd story without having to go to the Board of Zoning Adjustment. We're going to maintain the rule about non-use for more than 12 months. So if you don't occupy your structure continually, if you let it lapse for more than 12 months, and you want to reuse it, you need to come into conformance with the current use requirements. In short, it's this idea of use it or lose it. And then finally, we're recommending that for signs that are non-conforming. You might see a business that went out of business 5 or 10 years ago, and that sign's just sitting there. If it doesn't conform to the current ordinance, and someone wants to come in and reuse that office building or whatever the case may be, the sign needs to come into conformance with the current rules, whether that's as to the location, the size, the height of it. And so that's something that's somewhat in the sign ordinance, and we're just codifying that on nonconformities. So I know that's a lot of technical speak. I know it's a lot of stuff that can be difficult, but that's why we have the Q&A on. Kind of turn the time over to you, Caleb, when we go through that.
Thank you, Jeff. And I did want to emphasize one point that Jeff made that I think is really important, and that relates to administrative relief. Something that is currently provided through special administrative permits, which basically means there are parts of the city where today the Office of Zoning and Development can waive the requirements sort of through their powers. That will continue under here, but we're making 2 really important changes. The first thing is we're limiting how much can be waived administratively. So every standard in the zoning ordinance in module chapter 3 and chapter 8 is going to say for this standard, you can go this far, but anything beyond that has to go to BZA, has to go to Board of Appeals, which is Board of Zoning Adjustment, which has to go to the MPUs. That is a very, very big change. The other thing related to that that's really important in the spirit of transparency is that if you're a builder and you can't meet that regulation that you formerly could just sort of have staff review, if staff reviews it and approves that variation, you have to put the sign up. So what that's going to do is you as a neighborhood or you as an adjacent property owner are going to know that there was an administrative variation granted on that property. Again, nothing's changed in terms of the process except letting folks know that it's out there. Very, very important change. So what we wanted to do now was for about 10 minutes, talk, really 10, 15 minutes, we have plenty of time, see if there are any questions in the room or online about any of the sort of process stuff that we've talked about, or very, very high level questions related to the code rewrite. We don't necessarily want to go into details of the draft regulations, but if we have a couple or two, we'll certainly entertain them. So I'll start with the in-room first. I have a gentleman in the back.
Sure. So with NPUs, administrative review in particular, right now, oftentimes that staff component never comes back to the NPU. So yes, there's a sign, but one in the new code potentially allows a feedback loop with the NPU, so we get a mechanical review that happens on a regular basis rather than a posted sign where we're relying on neighbors to drive by a property.
So it would be shared with the MPU chair. It would definitely go out to the MPU chair, but because these are really properties that are already entitled, property already zoned, there would be a review and comment period, but there would be no official MPU vote. If that makes any sense. So the question was, how does the MPU stay notified when that sign goes up? Again, the permits will be, you'll be notified of it. The MPU chair will be notified. The MPU chair will sort of have to distribute it through their processes, but then there will be a way to provide feedback to the Office of Zoning and Development on that. But the projects do not have to go to the MPU for a vote. Yes, ma'am?
So I was late, so I'm not sure whether you covered this or not. But my question is regarding the zoning change to allow for single story or ranch homes to turn the basement into an apartment or making it a duplex. I saw that as one of your, I think it was a goal or something to provide more housing here in the city. So A, I want to know if that has passed and if that's now a new rule that I need to be aware of. And then B is if that is going to go forward, is the building department and permit the number of persons working in those departments going to increase so they can come out and inspect those homes. So
we had a question in the room about really about one of the previous modules, but I will answer it out of courtesy because we do have a lot of time this evening about what if the zoning ordinance allows people to build attached accessory structures, meaning they want to convert a basement into a second accessory unit. Nothing has passed yet. That would be part of the draft ordinance and it would be allowed in some zoning districts, but certainly not all of them. But that would not become law until this zoning ordinance passes, you know, later this year, next year, 2 years from now, whenever it happens.
okay, so who do I speak to if it's already happened in my neighborhood?
What it should, if that has already happened in your neighborhood, zoning enforcement would be the correct mechanism.
Okay, I'll come to you.
Great. Do we have anyone online? And then I'll take you, sir. Christopher Yinka, do you
Yes.
have any questions?
Yes, first question, pretty broad. Will either the new zoning code or the new CDP change any zoning lines?
No. As I mentioned before, we are not changing the property we're not changing the zoning on anyone's property. The zoning lines will remain as they are today. The names may change, but the types of uses permitted, the height, the density, that is all staying current. Now you, sir?
So if the zoning stays the same as currently is, then you mentioned change the name of the district.
Yes, sir.
So what does that mean?
So as I mentioned before, well, for those of you online, the gentleman was asking, what does changing the name of the district mean? And today our zoning districts have names from R1, R2, R3, R4, which basically means it's a residential district and it has lot size 1, 2, 3, or 4. Those sort of are different flavors of that. We're changing it in part of the rewrite to address the form, meaning the physicality of the district, how big the lots are, how tall the buildings are, what are the setbacks. And then there is a use district. So a property could be zoned house scale 1, which means it is a house scale and it's the lowest density. But then it would have a separate use permission called R1, which means 1 unit per lot. R2 would be maybe 1 unit per lot plus an ADU. So when you look at the zoning map, instead of R1 today, it would say HS-R1. So HS is the form, R1 is the district. And we have several videos on atlzoning.com that explain this. Module 1 would probably be the most applicable for those who are interested in this idea. Again, to find it, go to the project website, click Meet and Contribute, and then you can scroll down to the Module 1 meeting, which was in May? In May of 2024. And there's a whole video on there where Christy and myself and Director Holmes explain how it would work.
Okay, so these will be in modules. So this would be in module 1.
Yeah, that was Module 1. Yep. Christopher, I'm sorry,
I'd
ma'am?
like to ask, why is it that you cannot replace something that's already there, say a driveway? You just want to make it where the water has washed all because they did it with asphalt. And I want to go back and put concrete to kind of minimize the damage. But they don't allow you to do that on your own property. Why is that?
So there is a question about why doesn't the city allow you to replace stuff? The city currently allows you to make repairs, but at some point there is a threshold in which it becomes completely new, which is typically 60% of the value of whatever you're working on. And then at that point, it has to conform. Now, in the case of driveways, there are a whole bunch of other regulations that could be coming into play on your particular case. There are state regulations about the amount of impervious surface and stormwater runoff. And so those may be coming into play. Those are not essentially zoning standards, but generally speaking, the idea is that the laws have changed and there is a desire to conform with the new law. And that's sort of why you can't just keep rebuilding things forever and ever, except as Jeff mentioned, for certain uses, the house scale, the residential 1, the residential 2, you could do that under the draft.
Without, I mean, you're going back the same way. You're just making it safer. Now, I do have a water problem,
Yeah.
but that's caused by the city.
I would recommend you perhaps speak with Director Holmes after about specifics of your property. It's really hard to give general answers. Christopher, I see we have someone online.
Yeah, we do have a handful of questions. I'm getting clarification on one, but for the next one, is the automatic SAP exemption not granted in zoning districts that have DRCs? So they mentioned downtown, midtown, Buckhead, and Beltline.
No, there is no SAP required. There would be no SAP required in those areas, but they still have to present before a building permit is issued, could be issued. So you would file your building permit, you would go to the DRC. There would be, I believe, a 45-day window in which the building permit is held for approval. There could be comments shared, but at the end of the day, if the project meets the zoning requirements, it is their legal right to build as submitted.
In reference to destroyed properties, how does that apply to multifamily properties?
So if a multifamily property is destroyed, there are several provisions in the code today. If they are in a zoning district that allows multifamily, they can build back by right. But as you may recall from Module 1 as well, sorry, we're going back in time. There is a provision in the current zoning code, and it will be carried over into the new zoning code, that says if a multifamily building built before 1946 is destroyed by any means, it can be built to the same height and scale in the residential neighborhood. So for example, I live in West End. There are a couple of older apartment buildings from the 20s. They're all zoned for single unit, but if they burnt down today, they could build back to their same height and number of units under the current zoning and under the proposed zoning.
The current Beltline overlay code. Oh,
Did I have a question in the room? Or, okay, next one.
yes. The current Beltline overlay code identifies projects within the R1 through R5 or SPI zoning, not adjacent to the corridor, to be waived from DRC review. With most SPI districts eliminated, what is the new process for DRC review for these areas and districts?
We would, as part of the adoption, we would need to update the names, but it would effectively be the same areas that have have DRC review in the Beltline today. So it would exempt the houses typically, but it would impact all the commercial properties.
Will there still be CAM or CAV public hearings replacing SAP hearings?
No, there would not be. Though what this comment refers to is about 2 years ago, the legislature required Atlanta and a couple other cities to have public hearings of all administrative permits. They hadn't existed in the city for 44 years, and the legislature made that a requirement. That would go away as part of this.
Do the changes to the zoning names have any impact on property taxes?
No, the changes to zoning names do not impact property taxes.
Variances and
Christopher, I have a lady in the audience. Did you want to ask?
Yeah, my question is, permits that are needed for different projects, is there, I guess you want to say is there a different type of project that requires a permit, or some projects don't require a permit?
Yeah, so the question was, how do you know what kind of permit you need for a project? If you are zoned for the use today, you can go file a building permit in most of the city. So you live in a house, you want to add a rear addition, you need to file a building permit under the current zoning and under the proposed. There are some parts of the city that currently have another step that require you to get what is called a special administrative permit. These are usually the more intense areas, so like Campbellton Road has zoning that requires it, downtown, midtown, parts of Buckhead. So they would not need to do that administrative permit, but they would have to still go to a development review committee as applicable. So it really varies, but generally speaking, everyone will still need a building permit. If you're in an area where an SAP is required today, you wouldn't need an SAP unless you need a variance. And in our sort of review, we find that almost all SAPs do need some sort of variance. So we think that it will generally be very similar to what it is today. I know that's a technical answer.
But any type of renovation of a home should have.
Oh, this is a question of home. She's asking about home renovation. Yeah, those need typically a general repairs permit, sometimes other types of permit. Those are through the Office of Buildings. They really aren't affected by zoning at all, and unless you're going up or you're going back or you're expanding the home. Okay, Christopher?
Variances and special exceptions have different criteria in the current code. If special exceptions are removed, are there any changes to how things previously granted a special exception would be evaluated?
So yes, again, this is a very technical requirement. I'm going to try to explain it as simply as possible. Today, depending on what the rule is, depending on the rule you want to waive, there is one set of criteria for a variance, and there's another set of criteria for special exception. What that means is when Director Holmes gets that application, she has to read those and say, does this meet that? Does this meet that? Does this meet that? There are two types. We are getting rid of special exceptions, but, and this is very, very, very important, we know that there are certain types of standards that don't necessarily meet those general variance criteria, which are really size, shape, and topography. Because a lot of the new zoning districts that we've talked about for over a year are very design focused. And so it may not be a technical variance to do something that allows you to preserve a historic building. So all of those more designy things, I hate that word, but that's really what they are. When you read the applicable requirement in the code in chapter 3 or chapter 8, it will tell you under what condition can some of these be granted. So a great example is there are some zoning districts that have a parking maximum. There is no criteria today for varying a parking maximum. Under the new draft ordinance, there will be new criteria available for the director to review as part of that process. There will be new criteria for other things. For example, if your home is in a floodplain and you don't meet any of the other criteria, but your home is in a floodplain, that'll sort of supersede them all. So we're going to be unveiling the revised modules 3 and 8 as soon as possible. I don't have a date yet because so many moving pieces here, but when those do come out, which will be before the end of March, I promise you, it'll have all of those criteria for all of those other types of relief indicated. Do we have one more question in the room? Yes, sir.
So can you help differentiate between where we're drawing the line for special event permit versus special use permit? Because you mentioned market. So what if we have a building that says, hey, you know what, I really want to be a venue with a special use permit?
Mm-hmm.
So where are we kind of finding criteria for that? And how are we differentiating?
It really is the duration. Yeah. And as Jeff mentioned, it's something that is not intrinsic to the property. So this is a great example. This is an event facility. This is now a defined use in the zoning code. This is operating more than 90 days. But if Greenbrier Mall wanted to do a health festival in the parking lot and they wanted to run it for 3 weeks, there's no permanent structure, that would be a great example for this administrative type process.
So if they took an empty part of the mall, converted to a venue, and hey, we're hosting events for 90 days versus 91 days, it could potentially be a special use permit.
Yeah.
Right, so if it's 90 days or less, it's defined. If that type of event in a parking lot is for 90 days or less, it's defined as a temporary use. There are standards elsewhere in the ordinance that still have to be met about the hours, it's in the right district, etc. If it's greater than 90 days, it requires a special use permit. And the difference between that is this: a special use permit goes through a more robust review in front of the NPU, in front of the zoning review board, and then ultimately for a decision by the city council. And so that the temporary is at 90 days or less versus more than 90 days. Did that answer your question more or less?
Sort of. I might pick your brain out.
That's fine.
And I do think a really important distinction here is that use, that special event permit, the temporary use permit, is only for that particular event. It is not for a space to have a wedding one day and then a flea market the next day and then a pop-up rave the third day. Those are 3 different events. So if the space is being used in that way, it is not a temporary use, it is an event facility, which is a defined term under the zoning ordinance. Now there's always sort of, splitting hairs here, but that was the intention as we drafted it. Okay. Any more questions online, Christopher?
Yes. Next question is expressing some concerns about alignment between the Plan A process and Zoning 2.0. Would you mind just describing how the 2 processes are ensuring they're aligned? One specific example they give is if Zoning 2.0 reclassifies a parcel as low density, but Plan A designates the same parcel at high density, how is that handled?
The question was about aligning ATL zoning 2.0 with Plan A. Well, again, we are not changing any zoning. So you will continue to have the same zoning designation today, renamed under the new ordinance. and that is a sort of the one-to-one conversion. The comprehensive plan, which is a very long-term vision, may recommend something very different. So the classic example is you may have parts of the city that have been zoned industrial, and they've been zoned industrial since the 80s. When you look at the comprehensive plan, they usually often will show as being mixed use or some industrial mixed use. So what that means is that long-term, the comprehensive plan is encouraging that property be used for something other than industrial. But they still have a current industrial zoning because that is what they are zoned, that is how they are being used today. So where that becomes important is if that industrial property owner decides that they don't want their property zoned industrial anymore. The only thing they could rezone it to is a zoning district that conforms with the compatibility table of Plan A. So that would be one of the districts that allow mixed use today or districts that allow mixed use tomorrow. But as part of the adoption of the new zoning ordinance, we're not changing people's zoning, we're just changing the names of their zoning. Hope that helps. Any other questions?
Yes, if a zoning district will be granted additional rights, will those rights also be granted to a non-conforming use or non-conforming property within that district?
Not necessarily understanding that one.
I can rephrase.
Yeah, paraphrase.
So essentially, for a property with a legal non-conforming use, if it happens to be in a district that is now going to have expanded use permissions, expanded development standards, will those same standards apply to the legal non-conforming use?
If the use closes, they would have to meet the new zoning requirements. If the use continues as a legal non-conforming use, there are limits on what they can do. So they wouldn't be able to expand the building. They wouldn't be able to be vacant typically for more than a year, as Jeff mentioned. But the question doesn't make a lot of sense because the development standards, the zoning standards depend on what the use of property is. And as long as they are a non-conforming use, they have to meet the zoning standards for the non-conforming use. That really has no bearing if the zoning district allows restaurants and they're an auto yard. They don't get to do the stuff that restaurants can do because they're not a restaurant. Hope that makes sense. Yes, ma'am?
Why is it that you have that 1 year, 12-month rule on a vacant property as long as it's kept up? If it's kept up, you can't even tell it's vacant. Does that apply to that property? Or are you talking about businesses?
So the question is, why is there a 12-month rule that you can only be grandfathered for 12 months or you lose it? That has been the city of Atlanta standards for a long time. It's very, very common in Georgia. Some jurisdictions actually have a much shorter window. There is a huge caveat here, and I am not the attorney, and we do have an attorney here. Georgia has a lot of case law related to whether you're really not using it for 12 months. So oftentimes, if you are trying to lease it and you can't get a tenant and you keep the utilities on and you sort of prove that you're not abandoning the property, the judge will let you have more time. But if you really shut it down, you shut off all the utilities, no one goes in there, you shut off all the power, typically a judge would say that you've met the 12-month determination. Is that an acceptable legal answer, or would you like to clarify?
That's a great answer. I think the intent here is that if you have a use that's non-conforming and you continue to operate it, it's only fair that you do that essentially as long as you want. But if you cease it for more than 12 months, the intent is that any new use conform to the district. And the theory is that if it's no longer a conforming use, it doesn't further the public purpose. The idea is that those non-conforming uses go away and they be replaced with conforming uses in furtherance of the public health, safety, and welfare.
So a great example of that, I'm sure we all know ATL on Jonesboro Road. It's a large sort of impound yard. You know, imagine that was originally zoned industrial and now that's not zoned industrial. But they have the right to continue to operate under existing nonconformity provisions, which again come down both through the Georgia Code and the City of Atlanta Code. But if they really shut that down for 12 months and, you know, removed all the cars and put it up for sale, it's very likely that they would truly lose that grandfathering, never be able to open another facility there. But anything related to nonconformity is highly dependent on the specifics of the case. It's really hard to say an absolute yes or an absolute no with regard to nonconformity. So if you have any of those in your neighborhood or you own a nonconforming property now, please, you know, talk to a lawyer about that, because none of what I'm saying, none of what Jeff's saying is legal advice. We're giving general overviews based on generally how it is in the state of Georgia. Okay. Christopher, do we have any more questions?
Yes, we have one more. Will
Great.
property owners be notified of the zone and district name changes for properties? They're asking specifically if this will find its way to websites such as the Fulton County property website.
Great question. So first of all, as I said 2 meetings ago, the county records are never right with regard to zoning. So don't even pretend like they exist. Just ignore them. They're always wrong. So the county records, again, the county tax records are almost always wrong with regard to your zoning. You want to go to the City of Atlanta website, you want to look up the Atlanta Planning Viewer, and you want to enter your parcel in the City of Atlanta process, because the City of Atlanta regulates zoning and determines the zoning, the county does not. So with that said, there would not be notification of every single property owner about the name change. What would technically happen is the City of Atlanta would readopt an entirely new zoning map. That would again show what you are today and show the new name, but that would be a citywide adoption of a map as is allowed by the legislature. There's no notification requirement if you are adopting an entirely new zoning map, as long as you're just changing it from names like we're going to be doing in Atlanta. Okay. With that said, I did want to talk very briefly about next steps. We do have a couple of other things coming up. I mentioned that we're still working on the sign ordinance and the bonus provisions. We plan to post those to the website in sometime in mid-February. If you've signed up for an email, you will get a notice of those topics being out. We will also allow you to ask any questions on that through there. Again, we're not changing very much in the sign ordinance at all, other than incorporating the new zoning district names. We do have one more official scheduled meeting, and it's March 17th. I apologize for the error on the previous slide. That's my mistake. It is March 17th, 2025. We're going to have a Q&A session where we're again going to be spending an hour and a half, 2 hours answering your questions. We would love to get them in advance. You can go to the project website, you can review the ordinances there, and you can hit the connect with us or comment, and that will send an email to both me and Director Holmes. If you submit your questions in advance, as we've done for the previous meetings, we'll answer them up front. This is actually our preferred method because it lets us pull together exhibits and graphics and all this stuff that makes this technical material a bit more understandable. You can also send an email to atlzoning2@atlantaga.gov or call the hotline 404-546-0116. That is an automated hotline, so we won't actually pick it up per se, but we'll get it forwarded to my phone or our engagement team's phone, and we'll be able to call you back as soon as possible. And then finally, I did want to mention that tonight's meeting will be posted to the project website in a couple of days. We're streaming on YouTube, but it takes some time to be able to download that and Great. So with that said, I'd like to thank you very much for joining us this evening. If you're watching online, please go to atlzoning.com and click on draft documents in the top right to be able to review Module 9. Or if you're in the room, we do have some boards set up with an overview, or you can click the QR code. And again, thank you so much for being part of this process. And we look forward to seeing everyone in March.